You're looking at a man who asked we blur his face and that we not use his real name, that we call him Marwin, because as his ankle monitor serves as a constant reminder, his immigration case is still pending.
As I'm standing outside the vehicle.
He's never talked about that morning. He was on his way to work in Putnam County when ICE arrested him this summer.
The officer says, "Would you step inside the vehicle, please?" And I said, "Would you give me a minute to pray?"
In 2001, he says he left Guatemala and crossed the southern border without inspection by an immigration official, which is illegal. His lawyer tells us Marwin has a pending asylum case.
I was never arrested in my life.
Marwin says immigration authorities held him for more than 2 months in a detention facility in Michigan, away from his wife and 3 kids in New York. He described his first call with his 9-year-old.
And she says, "What is it that you're doing that you can't come home?" I says, I'm busy right now, but I'll make time. I'm going to come over. And then she said, to me, "Hey, Dad, will you play with me on the phone?" And I pretended that I was there.
At that point, he didn't know if he would ever go home. Usually when someone is arrested and booked by immigration authorities, they go before an immigration judge where both sides argue whether the person arrested should be let out on bond. But that hearing didn't happen for Marwin because of a little-known recent change by the Trump administration. In 1996, President Bill Clinton signed comprehensive immigration legislation into law, one of the key provisions for people who entered the country illegally without checking in at a port of entry and are later arrested. They can receive a bond hearing if they've been here more than 2 years. If they've been in the country less than that, they can face mandatory detention, and they'd be locked up without a bond hearing until their case is settled. But in September 2025, President Donald Trump's Department of Justice had a new interpretation. Now, anyone who entered the United States without inspection is subject to mandatory detention, meaning they're ineligible for bond hearings, whether they came 2 years ago or 20. That's why Marwin, who came here 25 years ago, was denied a bond hearing after being arrested last year.
Being there, you just give up.
According to data from ICE, there have been nearly 150,000 people detained from September to December of 2025. But how many of them are being held without bond hearings because of the Trump administration's new interpretation? The data didn't say. So New York 1 reached out to ICE, but we never got an answer. New York 1 spent months emailing nearly 1,000 immigration lawyers across all 50 states, asking how many of their clients had failed to receive bond hearings due to this new interpretation.
It's close to 50 since this rule change happened.
7 clients that have been detained.
Maybe half a dozen?
It's in the dozens.
More than 2 dozen.
200 lawyers who responded estimate collectively they've had more than 3,000 clients in the U.S. longer than 2 years and locked up without bond hearings. And one of the more surprising people we heard from is on Long Island.
So you were an immigration judge until
September 4th, 2025 this year.
David K.S. Kim was an immigration judge at 26 Federal Plaza in Lower Manhattan for 3 years when he says the Trump administration fired him without cause in September, a claim the DOJ declined to comment on. So instead of being on the bench, Kim is representing at least one detainee and sued the federal government to get him a bond hearing before one of his former colleagues.
I look at it more as protecting my clients' interests, their rights, especially due process rights, which I feel that are being violated by our current government.
Kim is one of many immigration attorneys who have filed habeas petitions, arguing the federal government is unconstitutionally detaining people based on the Department of Justice's new interpretation of immigration laws passed 30 years ago. The American Immigration Council tracked outcomes in these petitions for almost all of 2025. There are 28 federal district judges who sided with the government that these non-citizens did not deserve a bond hearing. 260 federal district court judges disagreed with the government, often calling for non-citizens to get bond hearings or to be released. Like Marwin, who was let out after more than 2 months because his lawyer successfully filed a petition.
It was like a nightmare.
And Ukrainian Larissa Kostak, who New York 1 spoke to in October from her Brooklyn home after she was held for more than 3 months in a Louisiana correction center.
And that's a huge miracle. I'm back home.
A spokeswoman with the Executive Office for Immigration Review within the Department of Justice says the agency declines to comment on litigation-related matters, and despite hundreds of judges ruling in favor of the detainees, they only apply in those cases, not to future ones around the country. So the issue has remained tied up in the courts, but one judge intended to change that in December. In California, Judge Sunshine Suzanne Sykes not only vacated the government's policy on mandatory detention, but agreed with the detainees' lawyers, ruling those who brought the suit should have been granted a bond hearing, and as should anyone similar who entered without inspection around the country.
So when you read that, how clear is it to you what her instructions are to the government moving forward?
So it's very clear.
Judge Shira Shenlin was a judge of the U.S. District Court for the Southern District of New York for more than 2 decades. She reviewed not only the California case, but a screenshot provided to NY1 by the American Immigration Lawyers Association of the apparent response by the DOJ's chief immigration judge, saying this ruling in the California case is not a nationwide injunction, and that the government's new interpretation remains binding precedent on agency adjudicators when it comes to bond hearings. Shenlin says this guidance is wrong.
They are essentially saying we don't have to obey the court's order. And that's a very dangerous thing.
So as it appears these detentions will continue, more individual habeas petitions are being filed, but doing so can be costly and unaffordable to many. Tens of thousands of dollars, according to lawyers NY1 spoke with. Marwin says people in his community lent his family the money they needed for his lawyer.
They were very, very generous.
To him, it was the only path forward, trying anything for his family to stay here in New York.
And we still believe that this country has a lot more to offer for anybody who's lucky to stay here.
Thank you for watching our YouTube channel. Let Spectrum News be your resource for balanced, in-depth political coverage, and click the subscribe button right here. You can also download our app or watch us on TV to learn more about the candidates, where they stand on the issues, and more. We'll see you then.